What should you know about inherited land? Have you ever wondered what happens to land when someone passes on? Let's say this could be a father, a mother, a grandparent. This could be a husband or a wife. What happens to their land when they pass on? Very many questions come up, like some people want to sell the land. How can we sell this land? How can we distribute this land among the deceased's family? How can we manage the estate of the deceased? Hi, my name is Joan.A. I'm a lawyer, and if you're new here, on this channel we talk about land matters. Basically, I look at the legal perspective of all land-related issues. So, normally, what you should know about inherited land, if you're in this situation and you're wondering where to start from, what you should have at the back of your mind, normally you have to have documentation in place that can enable you to deal with the land. Now, for instance, I can give you an example of land whereby a will was left behind. Where a will is left behind, it is not merely enough to say that I own this land because I was mentioned in the will that I will be owning 2 acres of this land. Why? Because basically you do not have legal ownership, so you don't own anything at the moment. So why do I say this? Is because let's say if we are dealing with titled land, yes? The names of the deceased are still on the title, meaning you don't have legal ownership and the legal ownership is still in the deceased's names. So, what you have to do to get legal ownership, to prove ownership of the land, if you want to sell it to someone or you want to distribute this property equally among the beneficiaries of the deceased, you can apply for letters of probate. Letters of probate are applied for before the High Court or the Chief Magistrate Court, depending on the value of the land. So you apply for letters of probate. These letters will enable you to change the names at Ministry of Lands when they verify these letters and they transfer the names and they cross out the deceased's name and they transfer the names to your names. Then you can effectively deal with the land however you please. What happens when a will is not in place? You apply for letters of administration. Letters of administration serve the same purpose as letters of probate. The only difference here is that in a will they voted, in a will our heir was already mentioned to manage the estate of the deceased. However, when you go to this side, the family has to sit down and vote someone they trust to manage the estate of the deceased. But however, when you have these documents, you can also go ahead and deal with the land how you please. Well, so it is very important for you to have documentation to prove ownership when it comes to inherited land. Words are merely not enough. Why am I saying that? Recently, I had a client that I was working on. This client told me he was facing challenges as regards to ownership issues. He came and told me that someone else was claiming to own his land. This is someone who has stayed on the land for 30 years collecting rent. Meanwhile, this is land where he assumed to be a heir from the mother. When the mother passed on, he inherited the land. But however, when I give you a background story to this person's narrative of the story, he says that the grandmother owned that land originally. When the grandmother passed on in 1967, the mother inherited the land. When the mother inherited the land, the mother did not update any documentation, file any documentation. The same thing happened when the mother passed on in 1986. The son inherited the land without applying for any documentation. When I talk about documentation, I mean applying for letters of probate or applying for letters of administration to enable you to deal with the land. So nothing like that took place. So I advised him to get letters of administration and to do a search to perhaps verify the current registered owners of the land, hoping that it would be the mother or the grandmother reflecting on the title. But however, unfortunately, what we got to find out was before the grandmother passed on in 1967, the land was sold in 1966. You get to see that the land changed hands before even the grandmother passed on, meaning that the mother didn't have any ownership of property, meaning she couldn't be able to pass on any ownership of property. At the end of the day, under the law, he is considered as a tenant, as a fellow tenant with the other tenants. So the other party that was claiming to be the owner of the land got more leverage because the person had documentation other than this person who was just giving a narrative of what he thought he owned. Well, this is all I had for you. If you have any question as regards to this video, you can kindly leave the questions in the comment section. I'll be happy to answer to them. If you think anyone can benefit from this video, kindly share it to them. You never know who you could be helping. Please like, share, subscribe so that this content can reach the right people. Until next time, bye.